the operation of state
And is it
law.
your view that Boyle comes out differently under Justice Kavanaugh's theory? I mean, I guess I'm trying to understand that if we sweep as broadly as this is a war zone and there's a uniquely federal interest, I thought that was also the case, not maybe the war zone part, but the uniquely federal interest part in Boyle. So doesn't it come out differently?
Your Honor, there is certainly a tension.
Or at least we don't need all the analysis that Boyle has to get to preemption, I guess. If we could just say at step one, uniquely federal interest, and that's the end of it, right?
That is not even the analysis in Boyle. Boyle, uniquely federal interest, was a starting point in Boyle.
Correct. So there was more to it, and there was a reason, because the understanding was that there still might be an opportunity or a circumstance in which you would have liability, even though we're talking about a federal government contractor dealing with the procurement of military equipment in a way that is obviously implicating federal interests.
That's certainly right, Your Honor.
So can you just say a little bit about the Badilla test? As I read your brief, in the last few pages, you seemed to say that if the court applies the kind of Boyle analysis here, it's the Badilla test that you would suggest. Why is that?
So we think that the Badilla test is more faithful to what this court's teaching in Boyle. Again, Boyle zeroed in on the federal government's interest in getting its work done and making sure that there wasn't a conflict between that decision and the state law duty. So Badilla looks close to that, and if we get to that, because Badilla actually looks at what the military has authorized and directed. So it is a test that closely tracks the military's decision and Boyle.